For more than 2 decades, we've been educating our listeners about financial topics that are most important to you. Do you have enough money to retire? How will you keep from running out of money? What's your plan for managing market risk? What about taxes, inflation, and healthcare? Each week, we talk with an advisor at Lucia Capital Group about these issues and more. This is Managing Your Financial Future.
And welcome back to the podcast. This is Managing Your Financial Future. Thank you very much. Johnny Dean, your podcast host, here with Rick, the Professor Plum, certified financial planner professional, accredited wealth management advisor. So I'm looking at this. A few weeks back, we asked the question, I think it was, who really controls your money when you're gone?
Oh, okay. I was going to say, that's a pretty straight answer.
Who really controls your money is nobody. No. Yeah. Who really controls your money when you're gone? And, we mentioned things, Rick, like whether your will actually controls everything you own, or your beneficiary designations aligned with your trust and your wishes or whatever. And then we talked about taxes, probate, family dynamics, and all that plays a role, and it can play a role in what your heirs ultimately get. And we did get some response on that from listeners, but some people mentioned something you brought up in that discussion, Rick, which was the fact that the state will write up your will for you if you die without a plan in place. And I know we can maybe get to some of that.
It's been very nice that way. Yes, every state has done that for you. If you are of the type too lazy, too whatever, too procrastinative to do your own will, the state has graciously, every state has graciously written a very specific set of instructions on where your assets will go.
Yeah, and by the way, that's not free. It's like the person that comes up to at the intersection in New York and squeegees your windshield and then has the handout. You have no choice. This is what's going to happen. And this got me thinking. We did a series of episodes, you might remember, last summer on 5 things you didn't know about, fill in the blank, Social Security and Roths and all that stuff. But we did not include the estate planning topic in that series. So I thought today, since it's still fresh in many of our listeners' minds, I thought we'd go through 5 things that most people, or maybe many people, don't know about estate planning. Because some of these, frankly, can cause real problems if you get them wrong. Now, Rick, I should say this at the top. I sometimes hesitate to talk about estate planning because so many people tend to look at that topic and think that it really doesn't apply to them, or at least not yet. But that's not true. It is an important topic, and you've seen that firsthand.
Well, it's an important topic because one of the issues that comes under the guise of estate planning isn't just what happens after you're gone. It's unfortunately happens for some people before they're gone, in the fact of who is going to help care for you when you cannot, either unable or unwilling to care for yourself. Well, and I've unfortunately seen this happen. I've been in this industry long enough to see quite a few different problems out there, and it's not a very fun time.
No, it isn't. And you mentioned this, so why don't we just get right into it? Because that is actually the very first thing.
Okay.
And by the way, we have I should mention this at the top. We do have an estate planning guide that you can download at luciacap.com. If you type in estate planning in the search bar, you'll see it. First thing comes up. It's free to download. Take a look at it. We talk about a lot of these things in that guide. But the first thing, since you brought it up, is that estate planning is more than just death planning, which, I mean, a lot of people, it talks about what happens after you're gone, but some of the most important documents, like you just said, Rick, powers of attorney, healthcare directives, that stuff is what happens when you're still alive, but you can't act on it.
Right, and it can be a very difficult time. There's a lot of emotions. A lot of times after somebody has passed away, obviously there's going to be emotions, but I think it might be a little bit easier after they're gone than to watch them basically be dying in front of you. And the emotions are really straightforward present. I saw a situation where somebody was very ill and there were allegations of domestic abuse. In this case, it was the wife that was basically gone into hospice at this point. And so what the courts did was they took all rights regarding her care away from her spouse because of the allegations and granted those rights over to her sister. So a family member is now in control, in charge of making decisions as it comes to this person's medical care. Unfortunately, there was no financial issue there the spouse still had control of all financial issues, including insurance and all that kind of stuff. And so it made the person who was in charge of the medical decisions, made it very difficult for that person, because they were dealing with how to care for somebody without a budget, without any say so of how that can be done and we're not allowed to talk to the insurance people, because only the person that's in charge of the financial side could talk to the insurance people. And so in dealing with that, they had to talk to the spouse, who was a complete creep, which is why the allegations were there, because they were probably true. Anyway, it just made for a very difficult situation. And when it comes into family, and unfortunately, this happens more often than not, when the powers are distributed differently, where you don't have one person making the decisions and helping and also acting in the best interest of that individual that's under the care, it can get very, very emotionally draining.
Well, emotionally draining, financially draining, you know, we're talking about death planning and it's life planning at the same time. I'm going to combine the first thing when we say there's 5 things. The first 2 are pretty much connected. The second thing is that you can end up in what they call living probate. If you don't have preparations in place, you know, you become incapacitated without a proper power of attorney. Your family may have to go to court just to manage your finances.
And unfortunately, I'm seeing this at this time too. I know somebody whose older sister is not doing well, has bouts of dementia, although it's not complete yet, and some other diseases that make their life not look like it's going to be a long time. It's not imminent, but it's not something that, they've got a long life expectancy ahead of them. And they're running the gambit between, can I get a power of attorney? Is there enough lucidity, is there enough lucid moments to be able to get a power of attorney? Or do I have to go to the courts and then have the courts then appoint me as conservator? And then so one way or the other, somebody has to be able to sign for this person at times, or will need to be able to sign for this person in the not too distant future. But it also then becomes, okay, what happens when that person does die? Have they made any provisions for what's happening with their estate after they pass away? And so you're dealing with it now while they're alive, but also looking at, oh no, I've got this hell coming up. Because what happens when, let's say this person gets granted conservatorship. The conservatorship ends when the life ends.
I don't think people understand the difference between when you say conservatorship and power of attorney. Just very, very briefly explain that.
Well, it's basically, one of them is the power of attorney is, if I am granting John Dean my power of attorney, I am granting all my rights and privileges of my assets, signing for them, signing away for selling them, doing whatever, all financial aspects over to John Dean. He can do what he thinks is in my best interest with those assets. He can sign. It's like, how do I sell something if I can't sign for it? Like with a car, you have we used to call them pink slips. Are they still pink? If I wanted to sell my car, I would sign the pink slip and turn it over. You take it to the DMV, and they would turn it over. If I'm not able to, or if I'm dead for that matter, how do I sign to transfer the title to somebody else? That's where, if I've given John Dean, he signs it, John Dean, POA, power of attorney holder, for me. And so now he's got all the rights that I would have in doing so. Power of attorney is granted by the owner of the asset when they're lucid. Conservatorship is the state that you live in stepping in and saying they cannot sign for themselves, and we are going to appoint somebody. So it's not the person appointing the next right of ownership, or not ownership, but right of power. It's the state determining who has the right of power over that individual. And getting the state to do anything is not as easy as you filling out a form and signing it.
Well, so the easiest thing to do is to take care of this stuff while everybody has their full mental capacity, and
yes,
and get this all in writing, put it in part of your estate plan. So these two things, they do go hand in hand. And I think I put these two at the top of the 5 things list because this is something that is very often forgotten about. Well, I've got assets that there's a lot of beneficiary designations, and it should be fine. But again, what happens if you're not dead? But you can't make your own decisions. And this is forgotten by so many people. So as you said, Rick, it's a time-consuming process. There's a lot of stress. It can be expensive.
Very emotionally draining.
Yeah. And so what you can do, let's just very quickly before we go on to number 3 here, the solution, I guess, Rick, is kind of what I just said, right? You have an estate plan that includes the proper powers of attorney so that you don't have to go through that. Is that what solves that problem?
It helps. I mean, obviously, you've granted the power so somebody can now manage it for you, and hopefully you're picking the person that you believe, because you know all the people in your life. You're picking the person that you believe is going to act in your best interest and has the capacity to do it. Financial capacity, I'm talking about, not mental capacity. And when I'm just talking about sophistication, acumen, training, education. We have people in our lives that would be wonderful caregivers, but you don't want to give them any financial control because they have no idea about financial control. And then there's other people that are very financially, savvy, and I'm not sure I want them controlling my care. I mean, they're not the most loving people, so to speak, sometimes.
Yeah. You picture them with a plug in their hand, right, is what you're saying.
Well, yeah, I'm hoping it's still in the wall, too. Yeah.
Possibly, but possibly not.
Well, that's another part of it. I mean, you need to have those documents, too. The physician's directive, healthcare powers of attorney, pull the plug, don't pull the plug, all those kinds of things. And those are all about before you die. I mean, if you've had any kind of surgery, you go in and you're signing up for everything. The doctors want, not the doctors so much as the hospital administration wants those documents so they have something to follow so that they're not making a liability call on what to do at that point. So they've got it in clear cut who they're going to talk to. So they don't have 3 siblings, or coming in and saying, he said this. Another one says, no, they said that. And they want to know who they talk to about what's going on if you're not able to talk for yourself.
Yeah, important stuff here. So, and any good estate planning attorney should include all this stuff as part of your estate plan. So, just think of it as more than death planning, and you want to avoid this what we call living probate when you're unable to answer for yourself or take care of financial documents and sign and all that. Okay, so those are the first 2. As I said, we kind of combined those 2. The third thing that you probably didn't know is that not all assets will follow your will or even your trust. I think a lot of people assume everything just flows right through their estate plan. But talk for a second about, beneficiaries, joint ownership, and all that stuff.
Well, the will, you talked about that. The will handles everything in your probate estate. But what goes into your probate estate? Only assets that do not have a beneficiary or do not have an operation of title go into your probate estate. So if I have a beneficiary listed on my account, my IRAs, my life insurance, annuities, things of that nature that have beneficiaries, real estate now in all 50 states can have a form of beneficiary deed on them. So where I can name a beneficiary on pretty much any asset, I can put a transfer on death, which is basically putting a beneficiary assignment on a brokerage account, transfer on death, payable on death. The POD or TOD, one has to do with brokerage accounts, one has to do with bank accounts. They're basically the same thing. They are adding a beneficiary name to the account, that when the owner of the account dies, that person that is named as beneficiary will get the money. And it doesn't matter that my will, my trust, I've told everybody under the sun that I'm giving my entire estate to John Dean. He's been such a good friend for these 30 years. Everything I own is going to John Dean. And everything I own is in my 401k, and I've got beneficiary and TOD on all of my accounts, and they all say almost anybody but John Dean. And guess what? John Dean ain't getting a dime.
Well,
because the beneficiary trumps it.
Well, because in that case, you had originally, in this type made-up example, you said, well, years ago, you put a beneficiary designation on your 401ks and all your other accounts, and then at some point you said, no, John Dean's getting all of it.
And it doesn't matter what order that happens, though. I could have said John Dean's getting all of it, and then later I changed the beneficiary from John Dean to somebody else, and guess what? John Dean's out. The new beneficiary's in there. So the beneficiary trumps anything that goes through probate. In fact, the probate won't even see things that there's a beneficiary to. Title, if I own something as joint tenancy with rights of survivorship, that right of survivorship trumps whatever my will says, and actually trumps whatever my trust says.
Now, do people need to set this up ahead of time? I'm sure usually when you have a 401k, you have a beneficiary designation when you set it up.
Right.
But a brokerage account, all
brokerage
that stuff.
accounts are less common because those you have to ask for. But pretty much when you start an IRA or life insurance or an annuity, they're asking you the paperwork. They should be asking.
All right, so not to take this too far off, but we talked last time, Rick, about what happens when you've got a sibling who's in a higher tax bracket, but they say I got 3 kids, I'm going to leave them all to the one with the greatest financial prowess or whatever, and they'll split it up.
They'll take
evenly.
care of their brother and sister. Yeah, or I can't tell you how many times I've heard this. I want everything to go to my son or daughter, whatever the case may be, but I want to make sure that they're no good down, spouse doesn't get a dime of this. I have heard that more than once, and it's like, that becomes problematic. And how much control do you want to put on things?
Well, it does. And of course, as I said, we talked about this a few weeks back. And if you haven't heard that episode, I think you should have a listen to it because we do address all of that stuff. But as you were saying before, the most important part of this is that transfer on death, payable on death, beneficiary designations, these will supersede anything that's in the trust or the will.
Just because I wrote it in the will doesn't mean that person's going to get it. It may not mean there's any money left over for them to get because it all went to medical expenses and other things. And this is where naming beneficiaries comes in handy because if I name if I'm a single person, I name my twin cousin-in-law the beneficiary of my life insurance or whatever. That money is going directly to the beneficiary, not into the estate. And that the money that goes into the estate is going to be used for the last expenses of me, my medical expenses and all that. But if there's no money in the estate, there's nothing to pay the bills with. So you don't have to pony up what's not there.
Well, and that leads to a whole other set of problems. So not all assets will follow your will. That's the third thing.
You got to know what's going on.
In this list of 5, that's the third thing. So the fourth thing that many people don't know, as we go through all 5 of these, the fourth one is that you alluded to this too. Probate it's not just slow, but it is slow, or it can be slow, but it's also on the public record, and anyone can potentially see what you had, who you owed, and who got what.
Well,
right?
and it's the idea of being public is that they're making an announcement. Okay, we have the estate of so-and-so to settle. If you have a claim against this estate, let it be known now or forever hold your peace. Kind of like that. So now they're basically saying, okay, everybody out there, anybody that wants to make a claim against this estate, make the claim against it. And so they're making it public so you can make that claim. Now, this could be like that movie Overboard where, the guy didn't like getting kicked off the movie or kicked off the job and not getting paid. And so he's going to put in a claim against the estate. They didn't even know it was is it a legitimate claim or not? Just I'm going to put a claim in just because until they prove it otherwise, I may have a shot at it. So
and that delays everything.
Delays it tremendously.
And it also increases the cost.
Oh, very much so. But you talked about it being public, but I think just the probate process, how slow it is, screws up things. That's where I remember years ago we had somebody who bought a life insurance policy. Their spouse bought a life insurance policy, but didn't fill out the paperwork correctly. Earlier I said, when you fill out life insurance 401k, they're asking for beneficiaries. This person called back in the old days when they had that 1-800 cheap term, and they did the paperwork themselves, and they never filled out a beneficiary. And 5 years later, unfortunately, they died. But because there was no beneficiary paperwork on a life insurance policy, it went to the estate. It was $150,000 life insurance policy. The person was married, long-time marriage, no problems there. It took a year, maybe a little bit more than a year, to get that life insurance proceeds to the spouse, who it should have gone to in a very short period of time. Once the death certificate was done, you turn the death certificate into the life insurance company, they write a check as long as there's nothing, fraudulent about it. It would have taken a month with no cost. But going through probate took like $10,000 and a year to get the money over. Luckily, they didn't need this money, but that's crossing the T's, dotting the I's, and doing this all before you're in a highly emotional state makes tremendous sense. It's just you.
Yeah, we talk about avoiding probate, and usually the answer
probate's a pain in the backside.
Well, the answer to avoiding it would be to set up a living trust and
set up your
I'm not saying that
set up your beneficiaries or a trust.
Yeah, and again, if you have a good estate planning attorney, they will be able to. Once they go through everything that you have, they'll be able to tell you, well, this could be a problem. This may wind up in probate. Let's make sure we do this, 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 and this, so that we don't have that. And plenty of estates, pass on to the heirs without any probate at all. So it's just a matter of having, as you said, having
proper
the
training,
T's crossed,
proper
I's dotted.
Things. Now, there are some assets that you want to go through probate. Assets that you want to have a finite time frame for people making a claim against you, a business, things of that nature, where you got 3 months or whatever to make your claim on probate. Otherwise, it's closed and you can never make a claim on it again. So sometimes businesses and other things they'll let the assets go through the business go through probate, small business, single portion, just to limit the time horizon for somebody making a claim against it. So there are, and this is where attorneys, love them, hate them, whatever, they have a job to do, and this is where the job is, and where they hopefully will do a good job for you.
It's where they earn their salt too. Yeah, I didn't know that. That's interesting. But probably a good idea. All right, so that's 4. The 4 we've done so far is that estate planning is more than death planning. Just to sum that part of it up, there is a living probate. If you're not prepared, you want to not end up in that particular situation. That's number 2. Number 3, not all assets will follow your will or even your trust. That has to do with understanding beneficiary designations. The 4th one was that probate is public and it's expensive and it can be slow, and you want to avoid it wherever you can. And then the 5th thing, the final thing that you didn't know or probably didn't know about estate planning is that the biggest mistake is not funding the trust. Now, we talk about, funding. People go through the effort of creating something, but then
spend good money doing it.
But then they don't wind up retitling assets into it, which means those assets can still end up going through probate anyway. Talk about that for just a moment.
Not every state is created the same. Some states, the probate process is nowhere near as draconian as other states. I happen to live in one of the latter ones where it's not a fun process. But for the most part, if you're going to go through the trouble of creating a trust, a living trust, what the next step is then to change the title of the assets that should be in the trust to the name of the trust. Your brokerage accounts, your house, your real estate, things of that nature. Not your IRAs, not your 401ks, not your tax-deferred accounts, but the other assets that you have. You want them in the name of the living trust, because if they're not in the name of the living trust does not own them. You own them. And when you die, everything that you own that doesn't pass by beneficiary is going to go through probate. And they can say, well, Rick had a living trust. Well, if there was nothing in the living trust, when you get a living trust, when you go through the situation where you're getting your financial plan, the living trust is one of several documents that usually come as a package. You're going to get the living trust, your directive, your physician's directive. You'll probably get powers of attorney, healthcare directives, things of that nature. But you're also going to get a new will. The will is called a pour-over will, and it basically says
P-O-U-R. Pour. It's like picture something pouring over something else.
And that's important, because what happens is you can make certain bequeaths in that area of things that don't have a title and things like that, like the good china that the kids don't want anyway. But it says anything that I forgot or did not put into the trust, upon my death, anything that would go through, that's not in the trust, put it in the trust. Anything that I have not specifically given away in this will, put it in the trust. To get it from my name to the trust, it goes through probate. Everything that goes through the will goes through probate. So if probate was the reason that you did the trust, you wanted to avoid probate, and then you didn't fund the trust, you didn't put your house in there, and the house is one of the bigger issues because that's usually one of our bigger assets. And when they probate a house, you may have $1 million house with a $700,000 loan against it, so you have $300,000 of value there. That's not what they charge the probate against. They charge it against $1 million. So it's very expensive. But we see houses a lot because for a long time when you refinance, now we haven't seen much refinancing in the last couple of years as interest rates went up, but a lot of times the bank or the finance company, mortgage company, would only make the loan to you personally. And so people would take their house out of the trust, put it in their name, refinance it, and then put it back in the trust. Oh, but they forgot that last step. And so they forget the house is not in the trust now.
The house is obviously a big thing. What about things like a car? I mean, do you see people putting that in the name? I didn't do mine.
It depends on the car.
That way.
A classic car, an expensive car, maybe, yeah. Especially since you tend not to drive those as much. But it's like.
But would that be included in the pour-over will potentially?
Yeah, definitely would include the pour-over will.
Okay, good.
Yeah. But you ask what accounts should go in the trust. Like your day-to-day checking, in many cases, you don't put your day-to-day checking. You only keep, $3,000, $4,000, $5,000, maybe $10,000 in there, and it goes from $5,000 at the beginning of the month down to $5 at the end of the month. Then you have your deposits come in, or whatever days you do things. It fluctuates. But instead of signing Rick Plum on my check, oh my gosh, does anybody write a check? The old days we had to write Rick Plum trustee, such as that. And it was just a pain to be. Yeah. But you would keep your bigger savings accounts, your emergency accounts, your brokerage accounts, all those other accounts in the name of the trust because there was real value there. In most states, there's a simplified probate for assets under a certain threshold. The threshold's probably in the $100,000 range now for most states. So small accounts, it's just going to go through a simplified probate. Still a probate, still public, still potentially time-consuming. But the big assets, why pay the state to allow me to transfer it to who I wanted to if I've already set myself up? I know who I wanted to go to, and that's what the trust is very good at doing. Trusts have two main reasons for doing a living trust. The primary is avoidance of probate. The other one is control. Both control before I'm gone, which we talked about earlier. If my assets are in a living trust and I am unable to act upon my own affairs, the successor trustee, who I named ahead of time while I was still, not emotional about things, comes in and manages my affairs on my behalf for me, even though I haven't died yet. And then when I do die, the trustee continues because the assets in the trust did not die. So the assets in the trust continue with the same ownership, same management, same. It's not under new management anymore. I mean, that changed before, and so it's not a big problem there. Probate, if I die without a trust, those assets that are not in the trust, how do I get them out of my name and into the name of the people I wanted them to go to, or the name that the state wants them to go to? That's probate. That's where the living trust, avoiding probate. But control is also an issue. Control for myself and control for heirs. I want to leave the money to all three of my siblings. I want that IRA to go to all three of my siblings. But two of them cannot handle money. And if they inherit $300,000, they will either be broke or dead within 6. And because they have addiction issues, they have whatever the problems are, I can't let them have that much money up that quick. So I make sure that my trust is written in a way that the trust can be the beneficiary and dole out the money, RMDs and all that stuff over life, but they don't get it all in lump sum up front. But so these are all things that you have to consider.
Well, and as we said, hard as it might be to believe, you go through a trust and don't fund it, I mean, it doesn't do you any good. And there are people who have done that, but they don't put the assets that need to be in it, especially the home. And that was one of our big things when we set ours up. So I'm glad that we took care of that. So those are the 5 things that you really need to know. I'm sure there are others, but these are important things to know. I said at the top of the episode that we don't talk a lot about it, but Rick, it's an important part of the planning process. I mean, we talk a lot about buckets, we talk a lot about strategies and 401k and Social Security, all the things that people tend to deal with on a more daily basis. But the estate part of it just doesn't.
It's not fun.
Well, it's not fun,
planning
and
for retirement is fun. We're looking forward to the future. We're looking forward to the things that we want to do, doing things. How do I set myself up? What's the best, most efficient way to do this so that I can enjoy.
Right.
And then you say, oh, but we need to talk about your estate planning now. You're going to die. It's like not fun. Talk about your buzzkill.
But it is an important thing to do because this goes well belong, estate planning is beyond having a will or trust. And as we said, what matters is how everything works together, just like a financial plan. Assets transfer, beneficiary set up, taxes are handled. And, whether all these moving parts actually line up with what you want to have happen, it's important to put this stuff together. That's why this belongs right in the financial planning process. I think some people assume their financial advisor doesn't deal with estate planning, but they should, because it's one of the jobs. You want to talk through this with your own situation?
Your financial planner cannot be your estate planner because they're not attorneys. They cannot draft legal documents. They can't give legal advice unless they're also an attorney. But they need to be able to educate you on areas surrounding estate planning, terminology, things of that nature, and making sure that the beneficiaries coordinate with what you said you wanted to happen. Check titling and say, well, did you realize that this is going to, having a review meeting with somebody and they're talking about how they've disowned their brother and then look at how was that just venting or was that real because you're still giving them 50% of all your assets?
Well, and you bring that, it's a good point I should bring up here at the end of the episode because, the attorney will put it together for you, but it's unlikely that the attorney is going to call you up after 2 years and say, hey, how are those beneficiaries doing? Is everything still good? And this, I think, is where the financial advisor needs to take over. Once the trust and the estate plan is set up, I think the financial advisor says, okay, now we got an eye on it. Let's make sure that everything's still happening the way you want it to happen. And this is how they work together. And as I was saying, if you want to talk through your own situation, you've heard Professor Plum talking about this, but the advisor at Lucia Capital Group who work with Professor Plum, we'll do that for you. 800-644-1150, 800-644-1150. You need to have an estate planning attorney, as Rick said, but once you get that set up, let's get the financial planner involved and make sure that everything is working the way that you want it to work. Don't forget, visit us online, luciacap.com, luciacap.com. I mentioned that at the top of the show. Check out our downloadable guides. I mentioned the estate planning guide earlier. Most of the stuff that we talked about today should be in that guide, but we also have guides on Social Security, bucket strategy, retirement income planning, more. Just head to the search bar in the upper right corner, type in what you're looking for, and you can download it for free right there. Subscribe to the podcast so you don't miss an episode. Find us on Apple Podcasts and Spotify. Look for Managing Your Financial Future. Subscribe and listen wherever you are. Out of time. Plenty more topics, though, coming up to help you manage your financial future, which, of course, is why we're here. For Professor Rick Plum, certified financial planner professional and accredited wealth management advisor, I am your podcast host, Johnny Dean. Thanks so much for listening. We will talk again next time. The information provided should not be considered specific tax, legal, or investment advice and is not specific to any individual's personal circumstances. Each taxpayer should seek independent advice from a tax professional based on his or her individual circumstances. These materials are provided for general information and educational purposes based upon publicly available information from sources believed to be reliable. The information in these materials may change at any time and without notice, and its accuracy cannot be guaranteed. There is no guarantee that any investment strategy will meet its stated objective. All investments involve risk, including potential loss of principal. Examples cited are hypothetical, are for illustrative purposes only, are not guaranteed, and subject to potential federal and state law amendments. There's no guarantee that you will achieve the results discussed or illustrated. The information provided is based on current laws, which are subject to change at any time. Lucia Capital Group is not affiliated with or endorsed by the Social Security Administration or any government agency. Social Security rules can be complex. For more information about Social Security benefits, visit the SSA website at ssa.gov or call 800-772-1213 to speak with an SSA representative. Roth IRA distributions of principal from a Roth IRA are tax-free. However, any earnings will be taxed at ordinary income rates, and a 10% penalty tax will apply if withdrawn prior to age 59.5 or within 5 years of the date the Roth IRA was established, whichever is longer. IRA withdrawals will be taxed at ordinary income rates. Withdrawals prior to age 59.5 may also be subject to a 10% penalty tax. 401(k) benefits may be subject to change at your employer, the governing pension, or benefit organization's discretion. Investments in real estate may be subject to a higher degree of market risk because of concentration in a specific industry, sector, or geographical sector. Annuities are long-term investment products designed for retirement purposes. Guarantees are based on the claims-paying ability of the issuer subject to their terms and conditions. Rick Plum is a registered representative with, and securities and advisory services offered through LPL Financial, a registered investment advisor and member FINRA SIPC. LPL Financial Insurance License Number 05-18721. LPLIA Insurance License Number 0B91442.